They hit Elon Musk with a $3.2 million fine, assuming he'd just pay it and move on. But what he did in that courtroom left even the judge completely stunned. It was supposed to be a routine morning in courtroom 7B of the federal courthouse in Fresno, California. The rain tapped lightly against the windows. The clerks shuffled papers, and reporters sat bored, adjusting their cameras and sipping coffee from paper cups. Then the door opened, and Elon Musk walked in alone. No security detail, no legal entourage. Just a gray suit, a dark tie, and an unreadable expression. People glanced up, curious but not shocked. Musk had been summoned for allegedly violating court protocol during a previous corporate litigation hearing involving one of his companies. According to the court's complaint, he disclosed sealed details from proceedings during a press event weeks prior. A clear breach of conduct, or so it seemed. Judge Deirdre Colton, sharp and precise, presided over the case that morning. Known for her no-nonsense attitude, especially when it came to high-profile personalities, she looked up from the bench, met Musk's eyes for a brief second, then returned to her notes. "Elon Musk," she began, her voice calm but firm, "you've been found in violation of federal court orders relating to sealed testimony. The fine is $3.2 million, to be paid within 14 days. There were no gasps, no dramatic pause. This was Elon Musk, after all, a billionaire CEO, a media magnate. A few million wouldn't shake him. But something about the way he stood there, hands loosely folded, no reaction, no objection, shifted the atmosphere in the room. Judge Colton leaned forward, perhaps expecting a response. "Do you understand the terms of the judgment?" she asked. "I do," Musk replied, his voice level. "But I'd like to respond now." Heads turned. A few reporters straightened in their seats. The man hadn't brought a lawyer. Yet here he was, asking to speak for himself in front of a federal judge. Judge Colton raised an eyebrow. "Mr. Musk, I recommend legal representation before continuing. With respect, Your Honor," Musk said, "I believe it's more appropriate that I handle this personally." She gave a slow nod. "Proceed." And that's when things began to shift. Musk reached into his inside jacket pocket and pulled out a single sheet of paper. Neatly folded, no binder, no folder. He placed it on the table in front of him. "I'm not disputing what I said publicly," he began, "but I am disputing whether the gag order applied in the context it was used." That raised eyebrows, a legal gray area. The order referenced in the contempt filing was tied to Section 35B of the protective hearing order issued on March 11th, he continued. But according to subsection 35B3, public safety exceptions permit disclosures under federal fair use exceptions, especially when the disclosed content refers to stockholder impacting risks. Judge Colton blinked once. Reporters began typing furiously. "I only mention one aspect of a manufacturing process that, if misunderstood, could have been dangerous for consumer use," Musk said. "I didn't name names. I didn't cite protected documents. I referenced my own concerns based on what I saw firsthand." The courtroom fell silent. A paralegal leaned over to whisper something to a colleague. Even the bailiff, who had been watching the door, looked slightly confused. Judge Colton raised an eyebrow. "Are you suggesting that you're protected under federal whistleblower statutes?" "I'm saying," Musk replied, "that the fine being levied against me may contradict precedent set in Stansfield Verde v. U.S. Tech Holdings, 9th Circuit, 2004, where the court ruled that executive disclosures serving a public interest cannot be penalized under seal protection if the statements fall outside the original parameters of the gag order. It was a specific case, a dated precedent. It wasn't a flamboyant gesture or showmanship. It was strategic, calm, surgical. And in that moment, everyone in the room knew it. But Judge Colton didn't like surprises in her courtroom, and Elon Musk had just flipped the script. She didn't respond right away. Instead, she leaned back, her fingertips pressed together, staring at the man who had just quoted circuit law like he belonged at the counsel table. For a long moment, the only sound in the courtroom was the hum of overhead lights and the occasional tap of a reporter's laptop keys. "Elon," she finally said, dropping the formality for the first time, "you realize that referencing precedent in this courtroom doesn't guarantee exemption. This isn't a theoretical argument. This is a federal penalty." Musk didn't flinch. I'm aware, but it's not theoretical. If the penalty itself ignores its own framework, it wasn't what Elon Musk said, but how he said it, calm, measured, like he'd practiced the lines 100 times, but not in front of a mirror. It came from something else, certainty, not arrogance, not charm, just clarity. The courtroom's atmosphere had shifted. Judge Colton was no longer speaking to a man accused of misconduct. She was debating someone who might actually know what he was talking about. A reporter near the back whispered, "Why didn't he bring his legal team?" Another leaned over. He must have wanted to make this personal. And maybe he had, because by now it was personal. "Mr. Musk," Judge Colton said, slipping back into a formal tone, "are you requesting a formal motion to dismiss the fine?" "No, Your Honor," Musk replied. "I'm requesting a reassessment based on Statute 12-8-7, F, Provision 4. I believe the court's penalty exceeds the bounds of what that statute allows in cases where sealed disclosure is nonspecific and intended to address imminent shareholder concerns." He paused and added, "I could provide examples of rulings that echo that logic." Judge Colton exhaled. "You're serious?" "I wouldn't be standing here if I weren't." There was something slightly off-putting about it, not disrespectful, never that, just unusual, like watching someone recite rules in a game they weren't expected to understand, let alone win. She motioned for the clerk. "Bring me the transcript from the March 11 hearing, and get the full ruling from Stansfield versus U.S. Tech Holdings on my desk by this afternoon." The clerk stood and disappeared down the hall, leaving a sudden quiet in the room. "Elon," she said again, this time like a parent trying to understand their child's logic, "you do realize what's at stake here? You're not just calling into question a fine. You're challenging the limits of courtroom discretion." He nodded yes, but respectfully. "Your Honor, if a court can issue unlimited fines for statements that weren't protected by the actual wording of the gag order, then what's the limit of that discretion? Where does it end?" A man from the Securities and Exchange Commission, sitting behind Musk, scribbled something into a legal pad. Another attorney from a rival firm quietly slid his phone out and started typing under the table. This was no longer a simple contempt hearing. It had become something else, a moment, a pivot, the kind of moment law students would write about years later. A defendant who chose not to fight the accusation with lawyers or theatrics, but with logic. Musk walked over to the side table, picked up a printed copy of the March 11th order, something he apparently brought himself, and handed it to the judge. "Pages 3 and 4, he said. "Third paragraph, you'll see the exception clause." Colton didn't even look up as she took the paper. Her eyes scanned quickly, her lips pressing into a line. "This court has discretion," she said. "But even discretion," Musk replied, "has boundaries." No one spoke. Then, slowly, Colton looked up, not with anger, not even annoyance, just something close to realization. She didn't dismiss the fine. Not yet. But something in her expression suggested the certainty behind it had cracked. If Elon had poked a hole in the dam, the real test was still coming. How far would the water go? By the time the courtroom reconvened after lunch, word had spread. Local journalists had already tweeted fragments of Musk's self-representation. National outlets began circling the hallway outside courtroom 7B, filled with camera crews, legal analysts, and people who never once cared about procedural statutes but suddenly found themselves asking, can Elon actually win this? Inside it was quieter but not calm. The air carried a strange charge, like everyone was holding their breath, waiting for a critic, a stumble, and he to prove he was just another tech guy playing pretend in a courtroom. But he didn't stumble. Musk sat at the same plain desk, hands folded, expression blank. He didn't check his phone, didn't look around. He just waited. Judge Colton returned, holding a yellow legal pad covered in notes. She didn't sit right away. "I read Stansfield twice," she said, "and I reviewed subsection 35B of the gag order. You were right about the exception clause." A slight murmur stirred in the gallery, but she continued, holding up the copy he had handed her. "This exception only applies in cases where the disclosure addresses direct threats to consumer safety, not speculation. Your statements in that press event suggested a potential risk, not a confirmed one." He nodded. That's fair. But the wording doesn't require confirmation, Musk replied. It requires good faith. That's a legal standard, and the court can't punish good faith disclosures that fall within that framework, even if the concern turns out to be non-lethal or exaggerated. She stared at him. You're walking a tightrope, Mr. Musk. I've walked narrower, he replied. A few chuckles slipped out from the back row. Even Judge Colton allowed herself the faintest smile, but just for a second. I also reviewed your timeline, she said, returning to the bench. You made your comments 2 hours after the hearing. That timing suggests you may have spoken before receiving the full written order. Are you arguing you didn't have access to the language? Musk shook his head. No, I had access. But the hearing's oral summary was unclear. The clerk emailed the full transcript 6 hours later, and by then, the press already had my statement. The courtroom hushed again. Judge Colton leaned in. So you're telling this court that you accept responsibility for the timing, but not the intent? Exactly. I was trying to alert shareholders to a pattern I believe might pose long-term risk. It wasn't about ego. It wasn't about headlines. And the data I referenced wasn't taken from classified documents. It came from our own internal audits. That makes it mine. A young lawyer in the gallery whispered to her colleague, He's pulling apart every thread. Her colleague whispered back, Yeah, and somehow it's holding. Colton flipped through her notes again, then looked up. You know, she said, this court isn't in the habit of being corrected by civilians. Musk replied without hesitation. Then maybe the habit needs review. It was bold, direct, but not smug. The tone didn't come from someone who wanted to win an argument. It came from someone who believed the truth mattered more than who said it. For a few seconds, the courtroom was still, not frozen, just still, like everyone had been knocked slightly off balance but didn't want to admit it. The judge spoke again, slower this time. You're forcing this court to consider precedent it hasn't had to apply in over a decade. I'm only asking the court to apply its own rules, Musk said. Colton tapped her pen against the desk once, twice. I'll take this under advisement. We'll reconvene in 24 hours for a final ruling. Until then, no further statements to the media.